Hi, welcome back. I'm Paul Ingbretson. This is our fifth podcast covering the subject of the Claremont decisions. And I'm going to just read you a little bit that I want to read at the beginning of these. Nothing more than that. I'm just going to say I'm going to go ahead and read it. It's an introduction. So I'm a full-time painter and teacher, so this isn't I'm not a politician, I'm not a judge or any of those things. I was 6 terms as state representative from Grafton County. And beginning in 2003, I'm one of a number of concerned citizens, including other former and current New Hampshire state legislators, who are very concerned about the unprecedented usurpation of legislative authority by our Supreme Court in the now infamous Claremont decisions of 1993 and 97. We've come together to produce a series of podcasts that will lay out the facts and evidence for your consideration. We'll be hearing from some of the best legal minds, one of which is here today in our state, who have followed the issues from the beginning. And our goal is to create public awareness of the serious separation of power implications of the Claremont decisions, with the hope of generating public resistance to it and any future such judicial overreach. So if you're concerned, as we are, with the loss of people's control over policy and taxation in New Hampshire and wish to help, please share these podcasts with as many people as you can. Share them with everybody on your list. And then consider donating so we can bring you and your friends even more of these important facts. Today I'm meeting with Ed Mosca, and thank you, Ed, very much for being with us. Ed is the former counsel to the Speaker of the House, 2010, 11? I think you said.
I think it's 11, 12.
11, 12, yeah, 11, 12, of course it would be. And under Bill O'Brien, and it was a pleasure to serve with you back in the day, Ed. I won't say any more except that you've written a couple articles, really, in my view, very readable articles, despite your thinking they'll go right over the head of a lot of legislators. They were then the Franklin Law Review in 2005 and 2006, and they're recommended reading. I think they're on our list. They're probably, at least one of them is in the Claremont Reader that Greg Sword put together. So let's just start out with a really straightforward question. What the courts have done is they've found a constitutional right to an adequate education. You want to explain that in layman's terms, what the heck they've just done and what that is even?
Yeah. All right. So let's do the explanation this way. Assume that we have 2 schools, okay? And these 2 schools are identical. We can make them identical in every aspect. They have the same teachers. They have the same students. They have the same physical plant. They have the same curriculum. They have the same books. All right, you with me?
Mm-hmm.
Same library, same gymnasium. And they're both generously funded, $18,000 per student each school, okay? So you're with me on that?
So far.
Okay. The only difference between these schools is this one here is funded with a state property tax. This one here is funded with a local property tax. Now, obviously, these students here are getting a constitutionally adequate education. These poor students, on the other hand, they are not getting a constitutionally adequate education.
Despite having everything
Okay?
being the same, okay?
All right. Now, does that make any sense to you?
Oh, yeah, no.
No. Okay. So, given that that's kind of ridiculous, not kind of, given that's extremely ridiculous, absurd, nonsensical, you have to ask yourself, why has the Republican Party in New Hampshire gone along with that for almost 30 years? That's what we were told in 1997 with that example that I just laid out for you.
Yeah.
All right. That's what the second Claremont decision, Claremont 2 in 1997, told us that the whether you're getting a constitutionally adequate education
Depends on who's paying for it.
depends on who's paying for it, which is nonsensical.
Right.
But the Republican Party has gone along with that for 30 years. In fact, two of your leaders now, I think the name is Jason Osborne, the majority leader, and guy from Salem, Joe Sweeney, have in response to the Conval decision, proposed a law to increase the amount of funding with the state property tax in order to, give a create a constitutionally adequate education for the kids in this school who are receiving a completely identical education to the kids in this school, but these kids are being paid for with a local property tax. Therefore, their education is inadequate.
So what's behind all this, Ed?
Um,
Why is this happening? What's the game?
well, that's a pretty broad question. I mean, with respect to, there are a number of things going on. Um, in order to understand the decisions, you have to understand the context. And to do that, you've got to go back to 1973. There was a U.S. Supreme Court case, San Antonio versus Rodriguez, I think was the name of it. And the plaintiffs in that case wanted the United States Supreme Court to declare education a um, constitutional right under the federal Constitution.
Okay.
The U.S. Supreme Court refused to do so, but in a dissent, either Marshall or Brennan, I'm not sure which, said, "Well, you know what? Don't let these guys in the majority stop you. Just go to your state courts and do the same thing."
Oh, wow.
That initiated a wave of litigation post 1973. Um, it came out in phases. It was first, I believe they call it the equality phase, where the plaintiffs argued that there was unequal funding between school districts and asked the courts to intervene. They soon found, however, that that was unpopular because that forced um, the more affluent school districts to spend less. And those are the guys that typically, the more affluent towns are the ones that typically fund left-wing causes. So they didn't like this. So they switched from equality to adequacy. That started about 1989 with a Kentucky decision. And what you have is you have um, multiple states whose constitutions were all enacted at different times, whose constitutions contain all types of different language. But incredibly, they all contain this same right to an adequate education,
So,
supposedly. Obviously they don't. It's a judicially crafted right, invented by the judiciary in response to this left-wing activist litigation. New Hampshire's not immune to it either. That's what happened in 1993. This goes back to 1993. That's when the Supreme Court issued the first Claremont decision based on adequacy. That's one of the things that's going on is that the New Hampshire Supreme Court decided to get involved in this judicial in this wave of judicial activism sweeping the country with respect to education, more specifically adequacy
yes. Yeah.
education. Another thing that's going on in order for you to understand this is that the Attorney General for the state of New Hampshire has really been complicit in this litigation. Let's say the last one, the most current one, the Conval case. The strongest argument that the Attorney General could make would be to overrule
Claremont.
this entire line of
Right.
decisions. As I think you're aware, the Attorney General has taken just the opposite position, which is that the court should, preserve this, not overrule Claremont, and just send the legislature back to do more work.
Yeah. Very helpful. Yeah.
That's a phrase that the Attorney General has used throughout. Um, the state needs to, quote, do more. Um, what this is it's politics under the pretext of defending the legislature in this litigation.
Yeah. Yeah.
The Attorney General is and has been acting completely politically.
Wow.
It's spanned numerous attorney generals, including the current governor, Kelly Ayotte, who, when she was governor, never argued that Claremont should be overruled.
Wow.
Not
Wow.
once,
Wow.
despite some very significant litigation and court decision and Supreme Court decisions being rendered during her tenure.
So we would expect
So,
nothing more from her now, would we?
oh, absolutely
Yeah.
not. She's gonna go along with what Ayotte's not to digress too much, but
My
Ayotte's
fault.
a creature. She's a creature of the legal establishment.
Yes.
She is not going to buck the legal establishment
This is a big problem in this state, isn't it?
in this state,
Yeah. Yeah.
right? Um, so you have as another thing, another phenomenon that's going on in here is that you have the Attorney General posing as the attorney for the
For the legislature.
legislature,
Yeah. Yeah.
but in reality, acting as a completely political player whose political goal is to push the um, adequacy
Yeah.
philosophy
To enable it.
of
To enable it. Yeah.
education.
Yeah. Yeah.
Something else you have going on
Yeah.
is that the going back to the first example that I used of those two schools,
Right.
the elected Republican officials, the state reps and the state senators, they really don't know what the hell is going on. You've done prior podcasts. I haven't done it recently, but I used to do a lot of these. And unfortunately, what happens it happens in most cases is that all the legalese, all the constitutional analysis, it just goes over people's heads.
Right.
And what it becomes is an appeal to authority. And you have your average GOP state rep or average GOP state senator saying, what do you mean the Supreme Court is wrong? The Supreme Court can't be wrong. They're the Supreme Court. What do you mean the Attorney General would not listen to the Attorney General? He's the Attorney General. Who are you? And you can write law review articles. I've written two of them. You can work through the text of the Constitution, the history of the
Right.
Constitution, the structure of the Constitution, explain it all, and it just comes down to them to an appeal to authority, and they're just conditioned to do. It's like COVID.
Yeah.
They're
Yeah.
conditioned to do what the authority figure says.
Wow.
Something else
That's
that's
pretty
going.
bleak.
Yeah, I think it's completely bleak. I mean, if you want to fast forward, I think my bet, if I were betting, is that whatever comes out of the Supreme Court with respect to this pending Conval appeal,
Right.
you're going to see a majority of the Republican Party, especially the leadership, um, go along with it, enable it.
Wow. So
And then one other thing that deserves mentioning, if I could just squeeze this in, is
squeeze.
that um, the prior governor, Chris Sununu,
Right. Right.
he had four picks,
On the Supreme
four
Court.
nominations to the New Hampshire Supreme Court.
Yes.
It's a five-person court.
Yeah.
If he had wanted to um, solve the so-called education funding
Yeah.
crisis, which, by the way, is a misnomer. We spend $22,000 per student. There's
There's
no
no
there's
crisis.
no dearth of education funding. If anything, we're spending too
Yeah.
much. But if Sununu had wanted to solve this, he could easily have solved it. He could have put four constitutional conservatives on the Supreme
Right.
Court, and just like that, the problem would have gone away because they would have overruled the Claremont case, which is an egregious example of judicial activism that's totally unsupported
Right.
as a matter of constitutional law.
Yeah. Yeah.
So I've thrown a lot at you, but
No.
uh,
No. That's
you gave
perfect.
me a pretty broad
No, it's a
question.
pretty great outline. That's a pretty amazing outline. So, you were the counsel at one point for the legislature, for the House, and if you were, Is there something you would and should have done, you being in that
Well, yeah,
position, and like step forward and defend us, defend the rights of the legislature, or the rights of the people against the Claremont
well,
usurpations? Is there something? Is there a failure
yeah,
here that you would have? You know how you
yeah,
could
I
have
mean,
handled it?
there's that thinking's the problem. It's never going to be fixed in the courtroom. You can make the most brilliant
Yeah,
legal
yeah,
arguments,
yeah,
and we have.
yeah.
This court doesn't care about, this court and prior courts do not care about who has the better of the legal
Okay,
arguments, but what the Constitution, if you cared about what the Constitution actually
right.
says, if you cared about the history of the Constitution, the structure of the Constitution, if you cared about any of the things that a judge is supposed to care about, you never would have reached this result.
Yes.
This is judicial activism and the idea that you're now going to come to the court with this new legal argument, and the judges are going to say, "Wow, you're right. For 30 years we've just been engaging in an exercise of you're right. Overrule. It's not going to
Oh,
happen."
so you're saying
Okay.
basically that we would have had to do what Trump did with the Supreme Court to get out of Roe versus Wade. You would have
That
had
would have
to
that would have been
appoint better
that would have
judges, and
been
Sununu failed us on that one.
that would have been one way to get out of it.
Okay.
I don't know if you remember, but back in 2011, 2012, I drafted this constitutional amendment that would have, if it had passed,
Yep.
would have solved the
Right.
problem. Um, it unlike other, I won't get into the details of it, but it was a compromise. It was something that Lynch actually went along with.
Huh.
So we had his support, we had the speaker's support, we believed we had a supermajority in the Senate, and we believed Lynch was going to get us at least one, if not more, Democrats to go along with it. So it would have been bipartisan in the Senate. We had a super majority in the
Yeah.
House. I don't know if you remember what
That was the
happened, but
280.
the uh,
Yeah.
the the uh, the Free Staters killed it. We could have been out of it back in 2012,
I do
but
not recall that that's what happened. Wow.
yeah, yep. We went through a lot. We went through a lot of work and um, expended a lot of political capital for no reason at all because they killed it. It would have solved the
Would
problem.
it have been would
But
it have been successful on the street? And give us a little bit of an outline of what it was that you did. Do
I, I, I
you remember the verbiage or anything?
what it did actually was it avoided the whole problem of talking about an adequate education, um, and rather than that, it set up in our Constitution um, education uh, a policy that at its root everybody could agree with.
Which is local control, that sort of stuff.
I don't
Yeah.
remember the exact language of it, but I think and I'm reluctant to say local control because that means different things
Yes,
to
it
different
does.
people.
Yeah. Yeah.
Okay, to
Yeah.
some people it means that the state delegates to the municipalities. To other people, some people have this, I think, rather far-fetched view that a certain provision in the first part of the Constitution creates this right. It's as far-fetched as the Claremont views, creates this right where local towns can do whatever they want, and they don't have to, with respect to education, they don't have to follow state law. So I'm a little reluctant to use that term,
Yeah, I get it.
but the amendment's just another example of what could have been done.
Yeah.
Sununu could have appointed judges. That would have been one solution.
Right.
Sununu could have appointed constitutionally conservative judges who very likely would have overruled Claremont because it's such a legal
Yeah.
abomination.
Yeah.
That would have been one
Yeah.
solution. Um, prior to Sununu, we had that amendment, which was bipartisan. It had Lynch's
Right.
support. I don't know whether it would have passed the electorate, but you
Yeah.
know, that was a huge achievement, getting a bipartisan amendment. It had never been done
Yeah.
before. But unfortunately, there was a large Free State contingent at the time, you probably remember, and they just went to war against it, and I still don't understand
Yeah.
why. And I guess the third thing that can be done about it is that the legislature can simply refuse to enact a decision.
Right.
What the entire history of the Claremont decisions have been that the court has baited the legislature, and the legislature at every turn has taken the bait.
Yeah.
For
Yeah.
example, if a court or the court stops short of ordering the legislature to enact a certain definition of an adequate education. Um, it said it said in the first Claremont decision, we anticipate that something to the effect of we anticipate that consistent with its constitutional duties, the legislature will promptly
Yes, I love this
fulfill
joke.
its duties
Right. Right.
by defining an adequate
Right.
education. Of course, what happens after that is you just picture it in your head, all these legislators and state senators, they go racing to the state house, falling all over each other, pushing each other out of the way to get their definition.
Right.
They're going back to our prior, a little early in our discussion, they're conditioned to do this. You have to uncondition them. I don't know if that's
Yeah.
possible. Uncondition them, teach them you're a separate branch of government. There is no way. There's only one aspect of the Claremont decision that's problematic, and that's the tax decision. Let's hold that, the tax aspect of it. Hold that in abeyance for a second.
Right. Right. Right.
Everything else, defining an adequate education, standards of accountability, blah, blah, blah. The court's powerless to enforce
Yes.
those aspects of its decision.
Yes.
As a practical matter, is it going to do?
Yeah.
Even the funding part of it, fund an adequate education, even the funding part of it, they're powerless to enforce.
Yes.
What are they going to do as a practical matter? Put all 400 state reps in jail until they pass a law defining an adequate education?
Well, it's been reported that some reps have asked that. What are they going to
Well,
do? Are they going to lock us up?
yeah, and the attorney general, this shows his
Yeah.
complicity in this,
Yeah.
said, oh, don't worry about it. We'll ask the court to be nice to you and not to lock you up, giving them the
Yeah.
impression
Yeah.
that they can be locked
Yeah.
up.
Yeah.
I know for a fact the attorney general did that previously. A state rep, he's now deceased. I'll leave his name out of it.
Mhm.
I asked him, why did you vote that way? He said, because they came in and told us the judges were watching and the bailiffs were going to take us to jail. I mean, it's crazy
This
talk,
is
but
madness. It's
they've
madness.
been they've been conditioned to believe this.
Right.
But what's a court going to do to enforce the
Yeah.
order?
Yeah.
Appoint a
Yeah.
special master who says this is the definition of an adequate education?
And then go sit in
As
and then go
long as
sit in the legislature and make us do it.
as, as, as long as the legislature ignores it, the court's powerless.
Right.
The only problematic part of the decision is where the court says that if the court struck a tax down, local property tax down is unconstitutional
Right.
because that's self-enforcing. People would just stop paying the tax.
Okay.
That's the only problematic aspect of
Huh.
it. But if your state reps and your state senators have the right type of plumbing, which they obviously do not, they would say, okay, you know what? We're going to call your bluff.
Yeah. Yeah.
We're going to call your bluff.
Right.
You strike down the local property tax as unconstitutional,
Right.
and I'm going to be every day doing a podcast, talking to a newspaper,
Right.
doing a radio show, saying how you, Judge Justice Donovan, and your cohorts up there close the schools.
Yeah.
You're going to own this.
Yeah. Yeah. Yeah.
Every single day, I'm gonna go to the news and I'm gonna tell them. I'm gonna arrange for protests outside this. That's never gonna happen though, because
No.
our
Well,
state reps and our state senators do not have the plumbing to do that.
yeah. Yeah. No, I'm with you. What's interesting to me is that we have people in the courts who just love taking power that isn't theirs. They just love power. I mean, this is what we're looking at here. That's my interpretation of this. What in the heck are we doing as reps that Didn't we come in here to express power in some way ourselves? And don't we love the power of the people? I mean, what is wrong with us? You're right about the plumbing. What are we doing up there? Are we just being nice people and trying to get some goodies to our little constituents? I mean, like, what world are we living in?
I
That's
mean,
rhetorical, but
the problem is, I forget which speaker said. I think it might have been SciTech who said this, that it's like with 400 people there, or even just reduce it to the number of
right,
Republicans. I think they're around 220 now.
right,
It's like herding cats.
yeah,
It's impossible to get them all moving in the same direction. That's how the court that's sort of what empowers and emboldens the court
yeah,
is they've known all along that there are enough Republicans who will break ranks.
yeah,
Well, the Democrats are totally unprincipled
yes,
on
yeah,
this.
yeah,
They'll, they see any means to get to the end.
yes,
They love these
yeah,
decisions. Higher
oh
taxes,
yeah,
bigger
yeah.
government,
It
more
fits
government,
their
more
whole
spending.
model.
They
Yeah,
love it.
yeah, yeah.
The court's pretty confident that no matter what, there'll be enough Republicans break ranks to go along with the
Yeah.
Democrats. Um,
Well, that underlies what.
you got to realize when they're sitting in their private conference, they're not talking about what Part Two, Article 83 meant or what
Unfortunately, yeah, yeah,
their calculus is how much can we get away with?
yes.
How can we write this in a way that looks like it's a legal decision,
Yeah.
yet bait the legislature to do our bidding?
So you're basically saying that the Supreme Court's the justices are unscrupulous people. You're not pretending about any of that. I mean, they're
The
usurping power they know isn't theirs, and they're doing it on these cynical basis that they can get away with it.
Okay, let me not paint with too broad a brush.
Well, that's what all you
On
lawyers
the
say.
first on the first Conval
Yeah,
appeal, one of the judges who there's a new justice since that appeal.
yeah,
Based on the decisions I've seen her, I don't know how she got through. Um, um, I don't know why Sununu nominated her compared to the other
yeah,
judges,
yeah.
because she actually seems justices, because she actually seems to be pretty good.
Okay.
She seems to know what she's doing, and she seems to know what the role of the judge is, which is not to sit as a in with particular regard to our present topic is not to sit as a super school board
Yeah,
or Supreme School Board. Okay, so I don't want to. She hasn't ruled on this yet,
yeah.
so I don't want to call her unscrupulous.
Well, we're
Let's see
talking
who's
Claremont, though. Let's go all the way back, though. I'm talking the Claremont Five. The Ghost hasn't made that decision. Your fundamental position, and I think Sorik's and everybody else's, is these people just made up law. They changed the Constitution by interpretation. It's
well, that should
unscrupulous. And then the way you're describing it is they then sit there and they say, well, we can get away with it because Rhino's in the Republican Party or whatever.
so, okay. Let me put it this way.
Okay.
Yes, but let me refine the answer.
Yes.
The most unethical thing that a judge can do
Yes.
is to substitute his or her or write his or her political views into the
Yes.
Constitution.
Yes.
That's what happened
But
here.
that's low. That's
Okay.
unscrupulous. Yes.
It's negated um, democracy.
Yeah.
It's overturned the results of an election.
Yeah.
It's much more than throwing a particular case. It's much more than coming drunk. It's much worse than coming
Yeah. Or
drunk to the
sleeping in the
bench one
courtroom.
day.
Yeah. Yeah.
Okay, you come drunk one day to work and you've messed up one case. Somebody got off on a drunk driving charge that they shouldn't have got off on. This is levels and levels and levels worse
Yes.
what this court has
I
done.
agree.
And let me go back to what I said before. At every turn, the legislature has gone along with it, which has emboldened the court to go
Yeah.
even further.
Yeah.
The court took a huge leap from Claremont 1 in 93 to Claremont 2 in 97. They lost one of the judges because it was such a big leap. And that was Justice Horton, and
Yeah.
he wrote in his dissent, I was, my problem with the majority decision is, I wasn't appointed to establish education policy.
Yeah, yeah, there we go.
Implicitly, and
So
that's
where
what they're
was he
doing.
in 93, 93?
Well, he was willing to go along with a little judicial activism. So he was, he was willing to be a little an itsy bitsy judicial activist. But then when he realized that he had unleashed a monster,
Okay.
he sort of recoiled a little bit and said, "Hey, I'm sorry, but
Yeah, yeah,
this is
yeah,
not what I signed up
yeah,
for. I didn't sign up to be on the state Supreme School Board."
yeah. Was Horton, was he a manor principal clearly enough before that? Was there any evidence of anything weird? I mean, I'm saying that only, it's interesting that at one point there'd be this little minor thing, and somebody at one point brought up the question of Grimes. He was 82 years old. He shouldn't have been on there. It was illegal. It was unconstitutional for him to even be participating in a decision because he was over 70. And that's a conversation. But I'm only saying that you have these judges that are already accepting things in the room. Why are they accepting even into the room if they're competent people who are scrupulous? Why did they accept an 82-year-old guy in that room? You know, I mean, I have doubt about their credibility that way.
Let me go back to the point I was making before, which
Yeah.
is I was there when they were doing this. I was there when they were filing the
Ah,
briefs saying overrule the decision because he shouldn't have been sitting. It is a waste, a
no, I get that.
monumental waste of time. It's just another example of how, instead of the legislature, um,
Doing their
use
job.
this phrase,
Yeah.
doing the right
Yeah.
thing and refusing to define an adequate education, calling the court's bluff,
Yes.
calling the court out, um, hoping, despite all the evidence and all the reality of the contrary, that somehow you're going to come up with this perfect legal argument, and the court's eyes will be
Yes.
opened,
Yes. Yes.
and the court will say, "Oh God, you're right, you're right. We're gonna overrule with 30, yeah."
No, my only hope in the court is actually that we give them enough grief that they get sick of it. But before that, who knows how badly they're going to screw up our state. That's not.
Well, you see, the problem is that a lot of this, unfortunately, is inside baseball
Yeah. Yeah.
because the people with the bully pulpit, the Kelly Ayotts, the Jason
Yeah.
Osborne's,
Yeah.
I hope I'm getting his name right, the majority
I think that's
leader, is
right.
that
No,
his
I think that's
name?
right. Yeah. Yeah.
Osborne, the Sherman Packards, the Sharon Carsons, they're essentially enablers of the
No, they
court.
don't have a
They're not.
history of being bulwarks. Yes.
They're
Yeah.
not they're not going to call out the court.
Yeah.
They're not going to criticize the court. And with all due respect, I'm sure Ayotte understands it. She just, as I said, is a creature of the establishment. I don't know if these other people even understand it.
Yeah. No,
I think for them, I think for Sherm, maybe for Sharon too, it comes down to, you're asking me to go against the Supreme Court? Are you
yeah.
crazy? That's like asking me to go against Dr. Fauci. Hand me my mask.
Yeah.
Back off. You're not 6 feet away from me.
It does sound like you're saying that the only theoretical hope is in the House standing up for itself. And other than that, there may not be any. I mean, am I hearing you right?
And yes, well, Sununu, if you really want to point fingers,
Yeah.
point the finger at Sununu, because we wouldn't be dealing with this right now had he put the right people on the court.
Yes. Yes. Yes,
Okay.
I follow you. Yeah.
So, point the finger at him.
Yeah. Nevertheless, that's past.
The
Yeah.
legislature should be blasting the Attorney General for not asking for Claremont to be
Yeah.
overruled. The problem, which we discussed before, is that the legislature, there's not a majority in the legislature who really wants this decision overruled. You have enough Democrats and enough Republicans who defect,
I know.
who would support the Attorney
Yeah.
General, which is,
Yeah.
yeah, okay, yeah, we'll do
Yeah.
more, just not as much as the plaintiffs want us to do, but we'll get there. We'll get
Yeah.
there.
And it's all about the money and fairness and all this crap. Yeah. Yeah. So, but that's still in the past. I mean, so yeah, you said it. We said it before. You present a pretty bleak picture. I still wonder how many people are out here like me, sitting here in a town like Haverhill, and wondering why nobody's irritated enough to go and run for office with this, nothing but this in mind, the loss of our republic. I mean, that's my way of saying it. This is the loss of our republic to an oligarchy.
Because exactly, but because you and I are throwbacks.
I guess we are. Are we all that rare?
Because most people be happy to live under a judicial oligarchy as long as they believe that it's the other guy being made to pay all the taxes. They're
So my theory is that the minute, as soon as we get this statewide property tax or whatever else they decide to tax the hell out of us with, income tax, at that point, we're still not going to do anything. But that's the only waking up point. That's the only theoretical breaking point that I can see, that the people all of a sudden look up and think, what the heck are you guys doing? But if we haven't done our work, but I'm thinking, if we haven't done our work, so go ahead, you go.
The Supreme Court is very cunning, very crafty. They have been. I assume they'll still be cunning and crafty.
Yeah.
They won't come out with a decision that says
it won't be black and white,
which is $10,000 per student. The decision will say something along the lines of, even the legislature has acknowledged that the state is not doing enough. Representatives Osborne and Sweeney have proposed bringing per pupil spending to $7,600 per student. Now, we're not saying that that's an adequate amount, but it's a good step in the right direction. The legislature needs time to do more.
Yeah.
They'll issue a decision like that, and then the state reps and the state senators will use my imagery again, just all be sprinting to the state house to propose all their little taxes.
Yeah. Oh, yeah.
And, some guy will say 15,000 per student. Right. Somebody will say 18,000.
And no matter what they say, there'll be another Conval.
And then there'll
be another Claremont who wants more.
They'll fashion a decision where, there's an increase in the amount of state property tax.
Right.
With an eye toward trying to keep as much as possible in the town.
Right. Right.
So it's not transferred, and then cobble together some other taxes.
Yeah. Of course.
I'm 99% certain that's the decision you're going to see from the Supreme Court.
Yeah, no, it makes sense.
They're too smart to go far enough where people say this is bull manure.
Yeah.
And either galvanizes support for an amendment or actually causes people to say, you know what? This is crazy.
Yeah.
This is insane.
Yeah.
Look at that great example that guy had of this school and that school. Yeah. There's no difference. How can these students be receiving an inadequate education and these students ignore them?
Because of who got them money. Yeah.
They won't go that far. They're too cunning. They're too crafty.
But they're also, you're saying they're corrupt. From my point of view now, let me talk about this way, because you don't want to say this, but I want to say it because, and I think it needs to be said, but that defines corruption to me. What you're saying is they're cunning and they're crafty, all this sort of stuff, because they have to be, because they're outside the law. Period. That's corruption to me. They're outside the Constitution. Any fool can see it with their plain open eyes. It does not take rocket scientists or lawyers to understand how far they've removed, how far they've encroached on the principle of the republic, of a democratic system. It's not rocket science.
I'll repeat what I said before, which is that I think the most unethical thing that a judge can do.
Yeah, I know. I'm with you.
Is to write his or her political views into the Constitution, because that's anti-democratic.
That's exactly right. Yeah.
People's votes.
Yeah. So
having said that, let me tell you that these judges don't see themselves as legal robber barons.
They don't see themselves as anti-democratic.
They see themselves as doing an immense public service. Do you remember the language of the language around when the first two Claremont decisions came out? Yeah. The courts didn't want to do this, but the legislature didn't do its job. The courts had no choice but to step in.
Yes.
They see they see
They're
their
righting the
role
world's wrongs.
incorrectly,
Yeah,
incorrectly, but sincerely, as
yeah,
that they're sitting up there as philosopher
yeah.
kings, and that it's part of their job to correct democracy when democracy goes
What
wrong. And
hubris.
they're not going to let those poor kids in
In
Claremont.
other words, they don't believe in democracy. That's as simple that. As simple as that. They don't believe that the people could
They
manage.
de they define democracy, I guess, the way Zelensky defines
Yeah,
democracy, where he doesn't have to hold elections, he can control the media,
right,
and
right.
he can outlaw certain political parties and certain churches.
You know, the courts
But
probably,
don't you
yeah,
dare call him a
the
dictator.
courts probably don't mind elections as long as they don't, as long as they can make what decisions for the House. They don't mind elections. You can have anybody in the House you want, as long as the court gets to make the decisions about what happens. We're in a very weird place.
And of course they're sensitive to that. That's why they've always written their decisions in terms of baiting the legislature. And at every turn, the legislature just takes the bait. And whether it's define an adequate
Yeah. Well, they
education,
make it easy.
create
Yeah.
standards of accountability, the legislature always takes the bait and says, the court hasn't done anything. The court has just explained to us. Yeah, I hear what you're saying that it just came out of the blue after 200 years. But these are judges. They have black robes on. Did they wear wigs? They even wear wigs when they go up on that bench. You want me to go against a man with a black
On
robe and a wig?
Yeah. No.
Who the hell are you
Yeah.
to tell this guy with a wig that he's wrong?
Well,
So I mean,
but
that's what they do. They've camouflaged they've camouflaged their political views as constitutional law.
so
And unfortunately, our state reps and our state senators, they don't know any
they're not too
better,
bright.
and they just go along with
They're
it.
just, you're saying they're not too bright. That's interesting.
Well, I was trying to
So
be, I'm
the
trying
courts
to
are
be,
corrupt, and the legislature just ain't too bright. I'm getting the picture, Ed.
I think I mean, the example, there was, I think it was 1960, in the early 1960s. You may have heard of this. They did an experiment down in Yale. They ran an ad in the paper, and they said, we need subjects for this experiment that we're doing. And people replied, they got paid, and they were told, okay, the subject of the experiment is that, we need volunteers for this experiment. And they were told, okay, uh, you'll be in this room and you have the ability to administer electric shocks. In the other room is the subject of the experiment,
Right.
and the experiment is to see how much shocking they can take. And so you had the actual subject was the person who responded to the ad who'd be administering the
Sure,
shock.
sure.
The person in the other room was an actor. He was not actually getting shocked. And in the room with the actual subject was a guy with a lab coat on. So the people who responded, the subjects of this experiment, were told, okay, level 1 electric shock. The actor would scream, and the person in the lab coat would say, continue, level 2. I said, did you hear that guy? He's screaming, and the guy in the lab coat would say, science, the interest of science demands you continue, and they'd keep shocking,
Right.
and none of them ever stopped. In fact, one of them, the actor pretended to die. Screamed, "You're killing me!" And then he jumped out of the
Yeah.
chair, clattered the chair on the floor. You could hear the chair clattering, and he pretended to be dead. The subject kept shocking
Oh,
him
stop it.
even after he was
Yeah, yeah,
dead.
yeah.
The whole point of it is people are conditioned to obey authority. The guy in the white lab coat, your state reps and your state senators, the person with the black robe and the wig,
Yeah,
or the person who says Attorney General.
yeah.
The
So,
nameplate on his desk says Attorney General. They're going to obey him.
yeah, no, I agree.
They're not.
Yeah,
They're not independent
yeah, I
thinkers.
know that. So what we have though is, it also looks like the lawyers are conditioned, doesn't it? In other words, they can't not do that. It's a very interesting thing you present there because it doesn't point at just at the legislature to me. These guys are sitting there in their black robes and they're just pushing it as far as they can. Isn't that interesting? So what kind of conditioning is that? What kind of a thing has already happened to these lawyers and why? What is it?
You're talking about the
I'm talking about the
judges?
judges. Yeah. Why?
No,
How are they
think
conditioned? Because you and I, we love the republic. We love the idea of the power of by and for the people. These guys love something else. Or but have they been conditioned to it by the way they went to school, by what they were taught when they went to school, blah, 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 or
Well,
just some personal need for authority?
the,
What you tell me, but
there are various rationalizations for it. Um, I'm sure that they will tell you, and they will actually can convince themselves that they're not acting in an unprincipled, unethical manner.
yeah,
They're just updating the Constitution.
right.
They're just
Well, they definitely are
stepping
doing
into
that.
fixed democracy where democracy isn't
Yeah,
working.
yeah.
Whatever other rational, myriad number of other rationalizations, but that's,
Yeah. Now, I know they always sweet talk themselves into it. Yeah, they always have a very good reason. Most murderers on death row do too. You know what I mean? I've heard the same thing, so we don't have to go there. So if you had a lawyer, if you were in the House now and you were the Speaker, you were the counsel to the Speaker, would you be in position and would you go to the courts? Never mind that they'll decide against you anyway, but somebody needs to say something finally that the AG will never say, and that is they're out of line. Would you do that if you were the counsel to the legislature? Would you recommend that to the Speaker and say, look, let me go to Conval? I want to present this. It's not going to do a dang bit of good, but it needs to be established in the record, the nature of this problem. I'm trying to give you, what's holding. Did Betsy, whatever her Miller, or whatever her name was, did anybody ever go and fight it on that level, even knowing that you're going into the court's own court, where they've already made the bad decision? How are you going to fix that there? You can't fix it, but you can you not speak out? Did we ever as a legislature speak out? And if you were there now, would you, and how would you? What would you do? Just for the purposes of having it on the record, if nothing else. Not about effectiveness or anything like that. Am I saying something that doesn't make sense? Yeah.
The legislature has oversight authority. You could, if you were the Speaker, Majority Leader, and leadership, you could bring the Attorney General in, ask him to come in for a hearing, subpoena him for a hearing,
Yeah.
and ask him to explain why you are not asking the court to overrule Claremont. And you can at that hearing go through all the legal arguments why, Claremont is as a matter of law is an abomination, is an absurdity.
Yeah. Okay. So you could have a hearing.
But our legislature doesn't do that. My understanding is, I was talking to a former, I got this from a former state rep, that Sherman Packard's position is that's not the New Hampshire way.
Oh, gee.
Man. We don't hold.
We're a bunch of smugglers and rebels. What the heck? What's the New Hampshire way? You got to do with it.
That's the DC way when you subpoena people and you put them on the spot and you hold hearings. That's not the New Hampshire way.
You have to fight for the Republic. What's wrong with that? Gee. So that's the conditioning.
That's the conditioning. I think probably a lot with Sherm too. Is Sherm's like he's a reversion back to the old type of speaker that we had when we used to have just a string of Republican governors who are essentially working for the governor.
Yeah. Speakers in that position working just for the governor. Yeah.
Yeah,
I could see that.
I could see that. I mean, if you go back to the prior governor, they conveniently got rid of a speaker who they didn't like working with.
Yeah.
Because he was a little bit of a loose cannon.
Yeah.
They made him agriculture.
Oh, right. Yes.
Whatever the title is.
Remember that. Yeah.
Put him out in a farm someplace. He's milking cows, and then they elevated Sherm because they knew Sherm was a go along, get along.
Yeah.
We can tell him, we can tell Sherm what to do type of guy.
But you're saying that it's impractical for me to even suggest this, but I am still talking theoretically for a minute, so that there's people with maybe a modicum of some sort of sense that maybe there's some kind of activism that ought to be done, whether or not it can be effective. And I'm talking about what we're doing right now. I mean, we have no power whatsoever. We just make noise. But we're trying to clarify the difference between corruption and usurpation and the righteous law of the Constitution and the powers of the people over everything else and all that sort of stuff. Is there my question is still that so you'd have a hearing, but would you go to court in Conval? would you go and tell the AG he represents something else, somebody else?
Well, I mean, the speaker, that gets back to what we were just saying.
Yeah.
The speaker would have to do that. The speaker controls the House
Yeah.
Counsel. He directs House Counsel
Yeah.
what to do.
Yeah.
Sherm is never going to do that.
Okay. But he ought to.
Sherm is,
But he ought to. He ought to say, you need to go over there and defend us. This AG is never going to do it. Sherm ought to be saying that. He ought to be saying, we need, you must.
Sherm,
He won't do it. No, I'm with you. That's your pessimist.
speaker-
I'm saying, but we actually have to put pressure on people to do the right things. We have to say what it is.
the Speaker of the House should be telling the Attorney General, you want those 5 new positions next year?
Right.
You got to justify to me why I'm giving you more funding when you were screwing us over.
Yeah.
in this
Yes.
fund allocation.
Yes. Now you're talking. Now you're talking Bill O'Brien. You're talking this guy he says you're going to give me a budget of 3 or 4%, or I'm not passing any of your bills when they come over to the House. Didn't he say that? Well, I'm just saying. Don't you understand that there is such a thing as power of the people, power of the Speaker, and all that stuff? That Sherm could write this in 2 seconds, in a sense, by simply the power of the purse.
There's a lot of pressure the Speaker could bring to bear.
Oh,
if
don't
he-
justify it. You don't mean to do that, I know, but you're practically justifying it. So, no, sorry, I didn't let you finish this, what you were saying.
Yeah, yeah. So I mean, that's one thing that could be done. I mean, you could ask Representative Osborne and Sweeney to come on your podcast and explain why,
Yeah,
when the decision is still on appeal to Supreme Court,
yeah,
that they're trying to enact it into law.
yeah. Why they still
Why
haven't stood up for the rights of the House?
Why are they increasing the cost of where did that number come from? $7,600. Why are they increasing the statewide property tax?
Yeah,
What's the thinking behind this?
yeah. I'm going to have to do that. It's a very good idea. We're almost at the end of our time. Is there anything we've significantly overlooked? Something maybe even wanting to bring up? Anything in the back of your mind that doesn't simply run the regular routes of of this conversation back and forth? Maybe do you have?
I think we were much too nice to the judges and the state reps and state senators, but aside from that,
I'm trying to do my best to go the other way. No, yeah.
no, I would, I'm so, let me say this. I'm sorry to be so pessimistic and so cynical, but
Yeah.
I've been doing this, sad to say, since 1993.
Yeah.
Okay,
Yeah.
over 30 years
Yeah.
that the Republican Party in this state has just gone along to get along.
Yeah.
Some of the stuff they've done has been creative. The statewide property tax, renaming local property tax, statewide property tax. I'm sure the powers that be behind closed doors are already trying to figure out how much, or already have figured out how much of the local property tax can we rename as statewide property tax without creating,
Yeah.
air quotes,
Yeah.
donor towns.
Yeah. Yeah.
What other taxes can we cobble together? What number do you think we can get away with at the court? I'm sure all that is going on.
Yeah.
As you say, it's a shame. It's more than a shame because that's
it's
not the
wrong,
way.
yeah.
That's not the way our constitutional institutions, especially the judiciary and the legislature, were meant to operate.
Yeah.
But that's where we're at. I mean, I've seen this for 30 years now, and I don't have and I see the legislature, that example I use of the majority leader and the assistant majority leader, increasing the so-called the cost of a so-called adequate education, more than doubling it, proposing legislation to do that. Proposing an increase in the statewide property tax. I see history just repeating itself.
Yeah. Yeah.
So I'm sorry to I'm sorry to be a pessimist, but
No, you bring a dose of reality to us.
I got there the hard way.
One of the things that's very obvious is that none of this stuff is about money. I mean, we're seeing schools educate kids for nothing. Homeschoolers can do it for a few $100s a year, and really outperform. You know, they get accepted very readily to the Ivy League schools, homeschooling families do, and all that sort of stuff. There's a whole, never mind that, but I mean, tons and tons of people that are doing it for $9,000 or $10,000. It's got nothing to do with money, but it does have, in another sense, something to do with money. There are people who are, if you're looking at the federal government, are just aggrandizing themselves. I mean, you look at to me, it's the NEA, the National Education Association. You're talking about people who are probably some of the pressures behind some of this junk. But there's a money element to this thing that's driving a destruction of the Constitution. And you can call it the sublime love of a good education, according to somebody's definition. But in fact, in reality, we're getting a worse and worse education. To put it in, you know, to really sort of sum it up, and we're getting nothing for our money.
I think part of the reason that education is so expensive in New Hampshire is because we have this extremely inefficient education delivery system that we call local control, where we set up this proliferation of SAUs that across the state, I believe we have over 100 SAUs that simply replicate from town to town administration that could be, if not centralized, extremely streamlined and would save a lot of money. And I think a lot of the frustration that people have is they go to the town meetings and they propose a cut in the budget. But what gets cut is not administration, teachers and programs. They don't want teachers and programs cut. In fact, teachers in New Hampshire are paid on average $20,000 per year less than Massachusetts. So when it comes to delivering education, there is no New Hampshire advantage. It's a New Hampshire disadvantage. And I believe if you want to talk about the money and reforming it, the place to start is by drastically streamlining these SAUs. It makes absolutely no sense. It would be like every single Walmart in the country having its own legal department, human resources department, marketing department, et cetera.
It would be affordable.
Makes economies of scale impossible.
Thank you, Ed.
A little bit off the topic of
No, but they start there. You know, they always start with this thing about adequate education and there's money thing. But we'll talk another time. But thank you, Ed, very much for being with me today. All we can do is light fires, and I think you've been a pretty good ember. Thank you so much. It's been nice to know you, man, just in general. Nice to see you again.
Likewise. Thank you.
Okay. Take care now.
Thank you.
If you're as concerned as we are with the loss of the legislature's control over policy and taxation in New Hampshire and wish to help, please share these podcasts with as many people as you can, and then consider donating so we can bring you and your friends even more of the important facts concerning our Supreme Court's Claremont decisions.